Hi, welcome to my YouTube channel, Coach Neighbors, Advocates for Justice Paralegal Service. If you're watching my videos, then more likely than not, you're struggling with a foreclosure issue. Today, we're going to talk about a few things. We're going to talk about who is the actual person responsible for the foreclosure against your property. We're going to talk about who should be the #1 defendant on your wrongful foreclosure lawsuit. We're going to talk about a few things that are assumed but are not true. We're going to cover the strategy that you should make to fight your foreclosure should make sense to a normal person. Okay. We're also going to talk about what to do when the clerk refuses your filings. We're going to discuss the truth about the manager-judge scam. And one important fact that everyone should know is attorneys don't have a license. We're going to spend a minute on that and Supreme Court case law that supports that fact. And that's Swear versus Board of Examiners. I'll put a copy of that case law in the comment section. The Supreme Court rules that there cannot be a license the state can't license the practice of law because the practice of law is an occupation of common right in Sims versus Ahearns. The last thing we're going to talk about is giving up the old way of thinking about foreclosure defense. But before we get into all that, I want to remind you guys, please, if you find value in what I'm in my video or what I'm doing to help other people, please subscribe, like, and share. Mostly subscribe to help me qualify for the YouTube Partnership Program, where I would be able to host ads on my channel and make money from hosting those ads to invest in my service. Please click the red button below to subscribe. And I'm also going to leave a few links at the bottom of the page down there in the subscription in the comment section. I have a link to my website, and I'll have a link to my Google reviews, and I'll also have a link to my Facebook page. Now, my closed group Facebook page is Foreclosure Rescue. We have members in that group that have invested in my program, and they're able to communicate with each other. The group serves as a support for all of the people that's fighting to keep their home. Whenever you have a question, if I'm not available right away, you can ask it in the group. And a lot of times there's members in the group that have had that same question and remember what the answer is. So they're able to help people out in the group. So you should click on that link at the end of the video and make sure you send me a request to join the group. Now, I don't allow people in the group unless you're actually in foreclosure. I don't allow people to sell products in the group because I can control the integrity of the group if I'm the only one that's selling the products and helping people. Now, people do help each other. We have a few special people in the group that have serious skills, and they're using those skills to help out too. I call those the angels in the group. We have angels in the group that like to keep a low profile, and those angels in the group have helped us do a lot of things, and we really appreciate them. So let's just get right into it. Who is the actual person responsible for the foreclosure against your property? Most people who are filing their lawsuit for wrongful foreclosure do not have the right person picked as #1 defendant. And the reason for this, in my opinion, is because of all of the things that we've been indoctrinated to believe that's not true. Like, for instance, most people think the bank's the #1 defendant. Most people list the bank as the #1 defendant in the wrongful foreclosure lawsuit because that's how the attorneys show it when they file the foreclosure against your property, as the bank as the #1 defendant. But you know what? I had to learn all this stuff from scratch. And in order to have some kind of idea what's really going on, because nothing's as it appears, I had to figure out a way to learn this stuff. And the best way that came to my mind to do this would be to use the signatures on the paperwork to decide who's responsible. not just assume it's the bank bringing the lawsuit, the foreclosure against your property, okay? Because that's old school. That's not true. My opinion is the attorneys are the ones doing these illegal foreclosures, and the bank's waiting in the shadows for the property to sell for a loss so that they can claim it, so that they can claim the mortgage insurance that you took out of signing. That's what I think is going on. So if you look at your paperwork, whether you're in a judicial foreclosure or a non-judicial foreclosure, in a judicial foreclosure, you're served a summons and a petition or a complaint or whatever. Okay, if you look at that complaint, on the last page of that complaint or the last somewhere on there is a signature. The signature on that complaint, that is the person that's responsible for your foreclosure against your property. The signature on that complaint is the person attacking your property. If you are in a non-judicial foreclosure, okay, the non-judicial foreclosure begins with a notice of default letter that they send out to you, okay? That notice of default letter is used to execute the power of sale clause in a deed of trust, okay? That letter is almost always signed by the attorney doing the foreclosure, and it's supposed to be signed by the trustee. If it's not signed by the trustee, it's a problem. That means that the person without standing initiated the foreclosure, and that makes the whole thing void. Yeah, it's the little things, okay, that get overlooked because the people that are usually people rely on helping with this is not trying to address any of those things for obvious reasons, okay? So that's the first thing you have to do. Check your paperwork and see who it is that actually signed. Because if you look on that paperwork, you'll see nobody from the bank signs anything, okay? There's no signatures from the bank, only the attorney's signature. And the attorney has to prove agency. That means the attorney has to be able to verify that they were actually hired by this corporation to do the lawsuit. And if they can't prove that they were hired to do the lawsuit, then that means they could be doing a lawsuit on their own, which is a fatal flaw to the foreclosure against your property, because they have listed as the number one plaintiff the lender. And I don't think the lender has a whole lot to do with any of the stuff that's really going on. So that's the number one thing. When you file your lawsuit and you add the attorneys, okay, as the number one defendant, and then you add the law firm as the second defendant, this blocks attorneys from the law firm from stepping up, okay? Because attorneys can't represent, an agent from the agency can't represent the agency in court. And when you do it this way, you cost them money, okay? Because attorneys have to hire attorneys to represent them when you add them, because they're not allowed to litigate a case they're a party to, and they can't represent themselves in court. So by doing it that way, it creates a little bit of a problem. And in a non-judicial situation, you always want to add a copy of your notice of default letter showing who signed it as Exhibit A. You want to add a copy of the deed of trust showing who the trustee is as Exhibit B. That's your evidence you need right there to show that the foreclosure is void and should be vacated, dismissed, or whatever the situation is, okay? The funny thing is, when you put your evidence in court, you file your evidence in court with your lawsuit, okay? Now, you don't have to have all these hearings for discovery and all this other stuff. You're ready to go to trial. And we've had situations where attorneys try to make an appearance on behalf of the law firm. So I put together a special motion to strike the attorney's notice of appearance when they try to do that. And usually we wait until after, before we execute that document, we wait until after they've already answered and used up their 21 days, okay? Then we move to strike everything because the attorney can't represent itself or the firm in court that it's affiliated with. So then we move to strike. And then once we move to strike the notice of appearance, you know, you can get creative. We've actually had we have one judicial foreclosure going on right now. We move to strike, and then we file for summary judgment. So when you move to strike, it's supposed to remove all the documents that they file because that person can't file the stuff. and now it creates an additional problem that they have. So you'll file for summary judgment and asking the judge to rule on everything that's actually on the court record, because there's no issues of that need to be resolved, because the eviction court or the foreclosure court did not have jurisdiction to rule because of the issues that you're pointing out. Number one, in a judicial foreclosure, there's never a witness. Okay, they do not have a witness to put before the court to give the court jurisdiction. In a non-judicial foreclosure, okay, the whole process is void because it was actually initiated by a party without standing. So you need to be aware that things are assumed that are not true, like the lender's the one foreclosing on you. The attorneys try to hide behind that. Well, it's a new day now. With the internet, people can do more research and figure out what's really going on. And if you take the time to stop and look at the signature on the document that you were served, you'll see that no one from the bank has signed it. Okay. The other thing that people need to understand is your strategy that you're using in your foreclosure defense should make sense to a normal person. Okay. I had a guy tell me one day that he had an attorney helping him, and in the end, they always find out the attorney threw him under the bus. And he told me that the attorney told him that they can file a lawsuit. I said, well, what kind of lawsuit was they going to file? Help you file? He said they told him they were going to file an antitrust lawsuit. It's like an antitrust lawsuit? What the hell? I'm sort of, he said, yeah, after the fact and after everything's all over and he had to struggle to find someone else to help him, he Googled antitrust definition, and the definition of antitrust is relating to a legislation preventing or controlling status or other monopolies with the intent of promoting competition in business. So that has absolutely nothing to do with a fraudulent foreclosure. Okay, so yeah, I know. And these attorneys tell people this stuff all the time. One of the things we want to talk about today also is what to do if the clerk refuses to file your documents. Now, whenever you file your lawsuit package that you buy from my website, okay, the first two documents that you need to file is the actual $5.5 million lawsuit, the claim, okay, and the restraining order. Those are the first two. You want to file them in that order. What you want to do is leave the restraining order in your packet, okay, and whip out the lawsuit. Okay, once you get the lawsuit filed and they give you a case number, then you pull out the restraining order and you handwrite the case number on the front page of the restraining order and you sign it and everything, and then you file it. If you file them both at the same time, they'll give you a little bit of a hard time because they kind of go back and look over stuff and they try to get out of filing if they see it's going to be a problem. But if they give you a hard time about filing your documents, what you need to do is you need to ask them, excuse me, what is your name and what is your position here? And most of the time they say, oh, my name is so-and-so, give you their first name and I'm a clerk. And then you would ask them, so do you have authorization to make a legal determination in my document? Because if they're refusing to file your document for whatever reasons, they're making a legal determination saying that it's not legally good enough. And most of the people have used that. The clerk stepped aside, they went and got the supervisor, and the supervisor came back, and you just tell them the same thing, because unless they're the judge, they don't have legal determination to they don't have the legal authority to make a determination on your paperwork. So you ask the supervisor the same thing. And most of the people have used this, they stop giving them a hard time. The other thing that they try and do is they try and say that your paper is not styled according to the filing requirements for your state. And you can Google what those are. If you do, when you do, you'll probably find out that the actual filing requirements and the requirements that they're making you do in court are not the same. And the reason for that is that the requirements they have in court are considered local rules, okay? And in my opinion, those are just rules that for attorneys that they use to violate people. Okay, these rules are set up to move things faster through the court. Okay, so whenever you're in court trying to get your rights, trying to reserve your rights and get a fair shot, okay, and things are moving faster than they're supposed to, then that means you're getting violated. Just plain and simple. So make sure you keep that in mind. Okay. One of the things that we want to let people know too is they hold us to a higher standard, the same standard as attorneys. And attorneys don't have no license. The United States Supreme Court has ruled the practice of law cannot be licensed by any state. That's state in lowercase and state in uppercase. It covers both the sovereign and the corporation. And that's under Swear versus Board of Examiners. I'll put this case law in the bottom of the comment section at the end of the video. And there's also the practice of law is an occupation and common right, which is Sims versus Ahearns, and I'll also have that case law under the bottom of the video. Okay, we have to give up the old school way of thinking about foreclosure defense. You know, stop and think about it. The foreclosure defense program, the conventional foreclosure defense program, was actually designed by the same bar members that's trying to steal your property. Think about it. Now, they only offer 3 options. You know, they offer a loan modification, they offer short sale, and bankruptcy. Okay, with the loan modification, they usually use that as a tool to disqualify homeowners, because you have to expose yourself by showing them your financial information. And once they find out that you have more debt going out than income coming in, then they refuse to work with you anymore. And then they start stalling. And they tell you we need the same paperwork over again, and we didn't get this. And then all they're doing is just stalling. Because in a non-judicial foreclosure, you only have 30 to 45 days before they're actually putting your house up for sale on auction. So they try to get you stalled that whole time, thinking that they're going to help you, and then find out that they're not in the end. It's really sad. So we have to have a different way of thinking. And the way I see it, okay, why go through loan modification once they file a foreclosure against your property? Okay, you can file your lawsuit against them. You don't have to wait until they kick you out on the street to fight for your property. And that's the whole difference between, I guess one of the biggest difference between my service and what we do. Okay, I provide the tools, and we make sure you understand the tools, and then it's up to you to get it filed and take care of it, you know. And the tools that we provide for you also block the eviction process. And that's the way we design what we do. And we got several people in our Facebook page. We have one lady in our Facebook page. Her name's Nancy. She just filed her paperwork last week, and the judge told her that he didn't care about the lawsuit that she filed to create the title dispute. He didn't care about none of that. And he went ahead and told her she was evicted and she had 5 days to get out. Well, on the 5th day, she got a letter from the attorneys. And the letter from the attorneys was an offer. They called it a settlement offer, okay? And what it was they offered her $5,000, okay, to dismiss her lawsuit with prejudice and pack up her stuff and move out. Yeah, that was a really sweet deal for her, right? But here's the thing, okay? The eviction was off the table. Okay, they gave her 45 days to answer to their offer. And they let her know that after 45 days, the offer was going to be taken off the table. And we're all like scratching our heads. Okay, these people are fighting to keep their house. What the hell are they going to do with $5,000? And they still have to move and rent another place and buy a house and do all this other stuff. Nobody's interested in doing that. But it was nice of them to make such a wonderful offer to them, because it let them know that they are back in the driver's seat now. Okay, and they're offering them the $5,000. Oh, wait. They filed a lawsuit against their property, and now they're offering them money. I think what we're doing is starting to work. So the way our program works, okay, we teach people how to create the title dispute you need to block the eviction court process. Because the eviction court in a non-judicial foreclosure, okay, in a non-judicial foreclosure, the eviction court can only make a determination on immediate possession, okay? If there's a title dispute, that court does not have jurisdiction, okay? So when you file your lawsuit in federal court and your restraining order, okay, you're creating the title dispute. That title dispute is what you need to block the eviction process, because it removes jurisdiction from eviction court. Now, I know they're hard-headed, and I think they really do believe that they have a right to do all the illegal stuff that they're doing, okay? So In our packet for the non-judicial foreclosure, we have a document to challenge the eviction, the jurisdiction of eviction court. Okay, and what you do is you attach a copy of your lawsuit that you filed in federal court, a file stamp copy. You attach a file stamp copy of your lawsuit to that motion to challenge jurisdiction, and you file that in eviction court. Okay, and then once you're done with that, I still don't trust them, so we figured out another way to move it. We have a notice of removal, and you take the motion that you file challenging jurisdiction and you attach it to the notice of removal as an exhibit, and you file a notice of removal in federal court, and you put your case number on there and everything. You tell them, hey, this is an immediate possession issue. I'd like to file it in my title dispute and make it moot, because immediate possession cannot be determined until the title dispute's been settled. And that's how we've been. We have even been requesting that the federal judge vacate the lower court's eviction judgment based off of all of that, and the fact that we have the title dispute filed in federal court. And that's been working out real well for us. I've got 2 more people that are at the gate right now with the title dispute. So one of the things that I put together, I have a new document package, and I put this package together because of the fact that the judge was ignoring the title dispute that was filed in a different court. So I figured out how to file a title dispute in eviction court as a counterclaim. So I put together, what I did was, so here's the deal, okay? Once a party has constructive evidence that there is a title dispute in a foreclosure situation, okay, then that party has to stand down until the dispute is settled, okay? They can't just ignore the title dispute in higher court and keep trying to steal your property. Well, they do, but that's not the way you're supposed to do it by law. So once they find out there's a title dispute, they're supposed to stand down. If they don't, and they continue the eviction process, okay, then you can go after them for wrongful eviction. Yep, I looked it up. It's actually a claim. You can have a claim against them for wrongful eviction, and if the judge grants the eviction to them and gives you the 5 days leave or whatever, then you can actually file that counterclaim in your eviction case against the judge and the attorney and the third-party buyer that's trying to buy your property, because they've all been given constructive evidence that there's a title dispute. And we actually had a lady that was getting, this is a brand new document I just put together last week, and the lady was getting ready to file it on Monday, and she found out yesterday that, the judge vacated the eviction order, or at least they just like pretend that they never gave him the order. I don't know, it's weird. But she's still in her house, and now she can fight for her property while she's still staying in her house. That's the goal. So if you are struggling with this situation and you need help that's unconventional, because like I said, we go unconventional. We don't do anything the conventional way, and you can't mix the two, okay? Because the conventional way is all fraud. The unconventional way is not fraud. And if you mix the two, then this is gonna make this stinky, pretty much. That's the way it rolls. So you have to remember, if you're gonna be in the program, then you can't be in the program and then think of it like you're in the conventional program, because it's not gonna work well for you, okay? If you're fighting foreclosure issue and you need help, look us up. You can give me a call. My number is 913-240-0227. Ask for Coach Neighbors. Or you can go to my website at winincourtnow.com, and I'll leave that link at the bottom of the comment section too. And check out our packages. Scroll down and check out the questions that people most asked. I've got reviews on the site. I've got a link to my Google review page. So I got everything's on there. I also have a link to my Facebook page. So if you're ready to fight, give me a call. Guy Neighbors, Advocates for Justice Paralegal Service. Thank you. Have a great day.